Okay, it's your application, I believe, Ms. Foley.
Thank you, Your Honor. We seek today an interim injunction pending the court's hearing and determination of the applicant's interlocutory injunction. We have filed material today, and I just want to make sure that Your Honor has what we have filed. I have filed an originating...
I haven't... Sorry, you keep going.
Thank you, Your Honor. We've filed an originating application as well as a concise statement in relation to commencing the proceeding itself. We've filed an interlocutory application for the injunction. We've filed a related interlocutory application, which is connected to the orders that we're seeking, and that's in relation to a separate bankruptcy proceeding, BID 222 of 2025. And we've also filed the affidavit of Jared Heath, which is our affidavit in support of the interlocutory application.
I have all...
Thank you, Your Honor. We should also have provided the court with some proposed orders.
Okay, I don't know if I've seen the proposed orders. I have everything else. Let me just see if we can track down the proposed orders.
Thank you. And I can probably start, if it's convenient to Your Honor, while you're waiting for those orders to come. They really track what we've sought in the interlocutory application.
Certainly.
Thank you, Your Honor. The reason that my client has sought an urgent hearing today can be briefly put. The respondents had recently threatened to engage in conduct in relation to a set of allegations that we've described in the material as the Flitner Allegations, and I will take Your Honor to those in a moment. The relevant conduct that the respondents have threatened includes filing affidavits in various court proceedings, which would have the effect of putting those allegations before the federal court and also before the Supreme Court of Victoria in a range of ways. And the conduct also includes publishing and disseminating the Flitner Allegations widely, including to the Chief Justice of the Federal Court, the Chief Justice of the Supreme Court, and to various lawyers. And then, yesterday, we also have had a threat, contained in material that was caught, to disseminate even more broadly than that, including to the media. That is the reason why we've sought urgent injunctive relief, and we're only seeking interim relief today. The Flitner Allegations, which I will take the court to in a moment, are scandalous. They are very serious, and if disseminated, they will cause significant reputational damage to a person in particular who is an employee of the applicant. And we've referred to that person as Person 1 in our materials, as well as harm to the applicant itself. In wider circumstances, which I will take the court to in a moment, those threats we say amount to threats to abuse the court's processes, both this court and the Supreme Court of Victoria, and also threats to commit a contempt of court. And so, we are taking action to prevent that from happening, the abuse of process and the contempt. But we've moved quickly, and we've sought an urgent hearing today to prevent the significant harm that we say will be experienced and suffered, in particular, by our employee Person 1, if the Flitner Allegations are disseminated in the way that the respondents have been threatening. So in a nutshell, that's why we've sought an urgent hearing today, Your Honor.
Okay. Could I just ask you, Ms. Foley, was there a request for suppression of the hearing?
No. What we have sought is a confidentiality order in relation to certain material, and we are also seeking a pseudonym order in relation to the identity of two individuals, but we're not seeking that this hearing itself be suppressed.
As it should be. Okay. I just wanted to check because the court is open, which is
reason, Your Honor. Yes, and I will be careful in the way that I refer to material for that.
Right, thank you.
But when we get to the orders that we're proposing, we are proposing several orders that would address the confidentiality and pseudonym orders that we're proposing. So, Your Honor, if I might just begin by going to the confidential and sheer to our concise statement, if Your Honor has the concise statement there.
I do.
Thank you. And at the back of that document is the confidential and sheer, which sets out the allegations made by Mr. Flitner.
Yes.
I'm not going to read those out, Your Honor, but I will ask Your Honor, if I may, to have a look at those allegations and in particular in paragraphs 1 and 3, which will give Your Honor a sense of the seriousness of the allegations and why we are seeking the orders that we're seeking today. So I will just give Your Honor a moment to have a look at those.
I've read those, Ms. Foley.
Thank you, Your Honor, and I should say that the threats that have been accumulating over recent times go to not just disseminating the allegations themselves, but most recently include threats to actually publish the video material that is referred to in paragraph 3. So they're very serious threats, and that is why we're here and why we're seeking urgent relief. Your Honor,
Sorry, Your Honor.
You will have your... Is that Mr. Kuksal?
There is an objection.
You will have your opportunity in a minute. I will just hear from Ms. Foley, and then you will have your opportunity.
Okay, thanks.
Thank you, Your Honor. We seek interim injunctive relief in the terms that are set out in our proposed orders, which match the orders that we set out in the interlocutory application pending the court's hearing, and determination of the interlocutory injunction application itself. If I can take the court.
Ms. Foley, I should let you know.
Yes.
Associate. We do not have the draft orders I've been told by my.
All right.
To the respondent. You might ask your instructing solicitor to send them through and.
We will do that.
Thank you.
Thank you, Your Honor. We will do that. If I can take Your Honor to the affidavit of Jared Heath, which was affirmed on the 21st of May 2025.
Yes.
Can I take that affidavit as read, Your Honor?
Yes, you can.
Westgarth. Thank you. Now Mr. Heath is a partner at Cause Chambers.
Your Honor. Your Honor, we were going to object to the admissibility of that affidavit. We would not like the court to have taken it to be read.
Right. On what grounds are you objecting?
On a number of grounds, but I do need 5 minutes to be heard about that.
Well, I prefer to decide that now, so would you like to tell me what your grounds are?
Yes, Your Honor. So firstly, Your Honor, if I may just bring up the affidavit itself. Bear with me. Okay, so Your Honor, firstly, the affidavit contains a number of hearsay allegations. The nature of the affidavit, for instance, where it relates to allegations that are made against me or assertions that are made against me, are in some cases third-party hearsay allegations. I will give Your Honor an example. In paragraph 7, Mr. Anstey says, I am informed by Mr. Heath says, I am informed by Mr. Anstey and believe that in 2021, the board became aware of concerns, so on and so forth. Mr. Anstey himself was not involved in any of the matters. He has given evidence to that effect. So Mr. Anstey, I'm speculating about this based on my experience with the tactics that the board employs. Mr. Anstey is, in effect, referring to assertions that are made by employees of the Legal Services Commissioner, who were at the time acting for the Legal Services Board. And based on the assertions of Mr. Anstey, which rely merely on the assertions of other employees, Mr. Heath is then narrating those assertions, and the effect of this is to prejudice Your Honor, and it is to effectively abuse the material improperly as tendency evidence, without going through the rigors of the safeguards that the Evidence Act places on the introduction of tendency evidence. This material that is completely irrelevant, I should add, to the case that is before Your Honor. Their case is not about whether or not I am a good person or a bad person, or I have a tendency to break the law or not, or tendency to do various things in relation to my engagement with the Legal Services Board. Their case is simply about whether or not the publication of the material is going to be in contempt of court and will effectively prevent the court from exercising its jurisdiction. They haven't clarified exactly how they're arguing the contempt matter.
Mr. Kuksal, you need to confine these submissions to the admissibility of the affidavit. If your points are in relation to hearsay,
Third-party
hearsay and prejudice to yourself and tendency evidence, then that's the submissions. If you want to go beyond that, they're for your submissions after Ms. Foley is finished.
Well, Your Honor, it's also relevant. So the first matter that needs to be identified to assess the relevance of the different allegations that are made. So what I understand Your Honor needs to do right now is to engage in a balancing exercise, under the discretion afforded by Part 3.1 of the Evidence Act to Your Honor. In exercising that discretion, what Your Honor has to consider is the probative value of the material versus the unfair prejudice that we are likely to incur. In order for me to effectively address Your Honor about the complete absence of any discernible probative value of the material, I need to be clear about the issues that are being raised, which are at the core of this matter. My understanding of the application that they're bringing, based on the document that was provided to us, that was sent to us last night, which we saw earlier this morning, is that it is alleged that the material, if it is used in the way they claim that we intend to use it, it will improperly intimidate members of the board and their employees against giving evidence. That's the nutshell of what I understand the purpose of this proceeding is, and that's any relevance that has to be assessed, in my understanding, has to be assessed in the context of that material, in the context of these issues. Now, in that respect, if I may address Your Honor, all the paragraphs that have been raised, that are included in the affidavit of Mr. Heath, up until at least paragraph 15, have no discernible relevance to the particular proceeding, and they are unfairly prejudicial, so they're unfairly prejudicial. Paragraph 15, I can see no relevance. Then, I don't see any relevance of paragraph. Just looking for the email that was sent to us yesterday, because the allegation, they basically scandalize the affairs of the court by making hearsay allegations of a very serious nature against me, without having any relevance to the matter. And I must add they're also an attempt at subverting an order made by the Supreme Court of Victoria. This is on paragraph, or subparagraph 18a. Now, so until subparagraphs 18a, paragraph 16 and 17, subparagraph 18b, subparagraph 18c, subparagraph 18d. Now, in relation to subparagraph 18e, I would like to add that it is alleged that, and this is alleged in, so, Your Honor, I'm referring to the concise statement now, if Your Honor has access to that, which I believe is a copy of the letter that was sent to us yesterday.
I've got the concise statement. But this is supposed to be submissions regarding the admissibility of the affidavit.
Exactly, and I'm going to the issue of relevance here, so just bear with me, Your Honor. All this material has been bombarded on us without notice. We're still making our way through the material. I apologize for that. Now, I'm regarding the relevance of the issue was set out in that email. Okay, so Your Honor, this is the email that was sent to us yesterday. I'm not sure if Your Honor has a copy of this.
Well, I will need to know the date and the time.
This was an email sent by Mr. Heath, dated the 20th of May. It was sent to the respondents at 8 o'clock yesterday. I saw it yesterday. I don't think Mr. Ansell saw the email yesterday. I have spoken with him briefly, and based on that, I make that assertion. Well, I'm happy to share the screen with Your Honor, so Your Honor can have a look.
No, thank you. No, not at this stage, thank you.
Okay. So, Your Honor, the email says, the only available conclusion in these circumstances is that the threats contained in the Ansell letter, Ansell Gmail and June email, are calculated by you to intimidate, harass, and improperly pressure the court in respect of its defense or prosecution of the extant proceedings. Does Your Honor have that email?
I can't put my hand on it at the moment, but that doesn't matter. Keep going.
So I need to. I'm trying to see if those words are repeated in the concise statement, because, so this is the email that we received at 8 o'clock or thereabouts yesterday, or it was sent at that time, rather than received. I saw it sometime after that last night. I hadn't read through the entire email last night. That email essentially demanded that the respondents give the Legal Services Board an undertaking against the, use of the allegations, or the evidence in support of the allegations, that Mr. Flitner and a number of other lawyers who have been targeted with unlawful adverse actions by the Board have made against various employees of the Board, who they accuse of abusing the Board's authority for personal benefit and for the specific detriment of those people. Now, I've provided an affidavit of Mr. Flitner, which was affirmed today. Can the court confirm that the court has a copy of the affidavit?
I certainly don't have a copy of it. Has one been provided to the other side?
Yes, and it has been provided to Your Honor's chambers.
Well, one of the problems with that is that the material is supposed to be provided to the registry, so if it has come direct to chambers, that might not be so helpful. I will see if the...
Sorry.
Has it been provided to the registry as well?
Your Honor, we were only told about this matter a few hours before the hearing, and we've done our best to get the material across. But the essence of the matter is that yesterday, the Board came to know that we were making complaints about these issues to the IBAC and to the Victorian Sector Commissioner. And after they came to know about that, they have immediately started threatening us and, basically, seeking undertakings to prevent us from making those complaints. We've also initiated communications with members of Parliament to raise these issues with them. These matters were first brought to the Victorian Legal Services Board's attention on May, and it was foreshadowed on the 7th of May that the material in our possession, and I'm not saying that anybody has threatened or implied that there will be publication of any videos. That is a misrepresentation, and it's made completely without basis. But there is an email that Mr. Flitner has sent that describes the videos that he had received from Ms. Joanne Jenkins, who he asserts has taken detrimental actions against him, and the Board has as well. These matters were raised to the Board on the period between 9 and the 19th of April 2024 by Mr. Glenn Thexton.
2024?
The Board. That's right. The Board accepted the substance of the allegations raised against Ms. Joanne Jenkins. It recommended that...
Your Honor, might I interrupt? As Your Honor knows, we are, in this hearing, going to be seeking a pseudonym order in relation to the name that my friend keeps repeating. I wonder if my friend, until that issue has been determined, can refrain from using a particular name. Or else I might ask Your Honor to rule on the pseudonym order earlier, if my learned friend is not content to be abiding by that courtesy.
Your Honor, I sense this.
Well, I will ask you now, Mr. Kuksal, to call, sorry, I don't think I pronounced that correctly, Mr. Kuksal, to refer to...
Kuksal.
Kuksal, thank you, to refer to the person in question as person. Is that acceptable, Ms. Foley?
So may I just confirm you would like me to refer to Ms. Joanne Jenkins as person 1?
Yes, and to stop using her name, please.
That's fine. I will do that. So in doing so, I'm not conceding the propriety of the court making a pseudonym order, but I understand that Your Honor will hear me about that later. Until then, I will refer to the person as Person 1. So the allegations concerning Person 1 were put to the board in an email exchange between Mr. Glenn Thexton, who is writing on behalf of Mr. Flitner, and Mr. Alex Wolfe, who is a partner at Baker & McKenzie. He has been instructed by the Legal Services Board and Commissioner to enter into the discussion with Mr. Thexton. This exchange is exhibited to the affidavit that we filed today. I can provide Your Honor with a copy of the exchange. So Your Honor, through that exchange, it is alleged that the board effectively accepted the substance of the allegations being made against Person 1, and the relevance of the allegations. If the court can confirm that Your Honor has the affidavit now, the relevance of the matter has been put in the body of the document.
I don't quite understand what you're asking, I'm sorry. But I thought—
So there was an affidavit of Mr. Flitner that was provided to the court and the registry on the other side today.
By whom?
By us.
Right. Well, I will ask Miss Foley if she has seen it. I have not seen it.
Your Honor, I have seen it, and I should say that we are very concerned about it because it repeats the very same allegations that we are here to seek an injunction in relation to. Your Honor, I wonder, having heard my learned friend's objections,
And
if I might respond to those.
I haven't finished my objection, Your Honor. I'm continuing with my objection.
All right. Well, Mr. Kuksal, we're not going to be here all afternoon on just the objections to the affidavit.
Your Honor, I need to rely on to be able to make the objections that I'm making.
Yes, absolutely. But this is an urgent interlocutory application. The assumption is that people will deal with things as expeditiously as possible.
But, Your Honor, the laws of evidence still apply, and Your Honor has to exercise Your Honor's discretion in accordance with the formalities set out by Section 192 of the Evidence Act, and Your Honor's discretion is entirely constrained by Part 3.11 of the Evidence Act in relation to the admissibility and exclusionary criteria of evidence. And I'm specifically referring to the abuse of the material for lack of relevance, in a way that is unfairly prejudicial to the respondents, and in a way that is sought to be abused as tendency evidence against the respondents. Your Honor has to perform an evaluative judgment. There is no discretion that the court has beyond the evaluative judgment that is to be performed in accordance with Part 3.11 of the Evidence Act. The fifth annexure to Mr. Flitner's affidavit is, in fact, the submissions that we had lodged in the bankruptcy proceeding, where we set these matters out very clearly in relation to the discretion that the court has to exercise under the Evidence Act. But in essence, what I'm saying to Your Honor is that the substance of the Heath affidavit is that it is slandering myself and people associated with me, based on hearsay material, without any cogency, without any basis for substantiating the veracity of the hearsay material. Then it is making presumptions and speculations. It is also contextually incomplete, in the sense that they have not even included the only correspondence that they sent to us at around 8 p.m. yesterday, to advise us of the purpose behind put us notice of. These are not documents that they could have prepared within a few, because this court does not have jurisdiction in relation to any matters in the jurisdiction in relation to the Supreme Court of Victoria, so any purported objective, bringing an application to prevent contempt of court, would have been that particular proceeding. Now we also say that this is an improper attempt at subverting our seeking these orders. And our understanding of the purpose, we haven't had time to review all the documents that they've been preparing, which, by the way, they never minutes. We say that the alleged purpose of the proceeding, as it was conveyed to us via the email that was sent, is to prevent a contempt of court in relation to the bankruptcy matter in a manner that is not compatible with the law, because the law requires them to raise the contempt application as part of the same proceeding. The federal court rules that it is a must that any application in relation to contempt of court is brought in the same proceeding to which it relates. So this is in relation to a threatened contempt of court, only in the Federal Court Supreme Court of Victoria. This court does not have appellate or supervisory of using this court to prevent us from filing material in the Supreme Court of Victoria is completely unfounded. There is no basis for that. As far as the bankruptcy proceeding is concerned, the appropriate vehicle for fundamental right that's guaranteed under the Constitution to engage in political speech. And I refer Your Honor to the following authorities in support of that assertion. This is Lange v. ABC, 1997, 189 CLR 520. In that authority, the court had emphatically stated that there is a right of political speech, which basically extends to all matters of government, state and federal. People are allowed to make, and they have a privilege, which is a defense against defamation, as well, in relation to any criticisms or discussions of matters concerning the employees and officials that are involved in the administration of the government. This is in keeping with the ability to check the performance of the government and ensure that the responsible and representative form of government is kept intact. Coleman vs. Power, 2004, 220 CLR 1, also emphasized the same matters, that communication in relation to executive bodies and the conduct of executive bodies, the character of persons working for those executive bodies, all of those matters are protected speech under the Constitution. We also refer to Bennett vs. President, Human Rights and Equality Opportunity Commission, 2003, 134, FCR 334. Again, it was emphasized that all actions of the executive branch, including those of statutory and regulatory bodies, fall within the scope of political communication. Communication of those matters is particularly protected under the Constitution, and I can refer to the specific sections of the federal Constitution that are in play. Hogan vs. Hinch, the famous authority on contempt, again emphasized the same matters, that political discussion of the administration of justice and the affairs of executive agencies are protected speech. Union NSW vs. New South Wales State, 2013, 252, CLR 530, again, said the same thing. I'm just going to read this part, which encapsulates the essence of what I'm saying. A law, including a law of a state, will be incompatible with the freedom of political communication inferred from the Commonwealth Constitution and hence invalid, according to Lange vs. ABC and Coleman vs. Power. If the law effectively burdens freedom of communication about government or political matters, either in its terms, operation or effect, and the law is not reasonably appropriate and adapted to serve a legitimate end in a manner which is compatible with the maintenance of the constitutionally prescribed system of representative and responsible government, it has been proposed that the second branch of that test, that is called the Lange test, involves two inquiries. The first concerns the proportionality between the legislative objective and the means adopted for its attainment. The second concerns the proportionality between the law and the maintenance of the constitutionally prescribed system of representative and responsible government. From that I ask the court to infer this, whether the orders sought on their face are necessary for the purported objective for which they are sought. This is not a plea to seek an injunction against defamatory publication. O'Neill vs. ABC clarifies that this sort of an injunction cannot be provided by the court. Ms. Foley repeated before Your Honor the allegation that it would cause irreparable reputational harm to the employee. That is a claim about defamation. And this hearing is not a hearing to seek injunctive relief against defamation, it's a hearing to purportedly prevent a contempt of court. So relevance has to be in relation to whether or not a contempt of court can be caused by the publication of the material in the manner in which they're saying that it will otherwise be used. Now, does Your Honor need the citation for O'Neill vs. ABC?
No.
Okay. The second matter that I wish to raise, Your Honor, is that it is alleged that the way the contempt would be committed is by intimidation of persons who may be witnesses. This is why we have requested the Board to provide the court with a copy of the transcript of the hearing on the 15th of May. Now, Your Honor, may I take Your Honor to the transcript of the 15th of May? This is relevant.
Where is that? Where do I find? Is that attached to the affidavit you're asking me to look at?
No, Your Honor. This was provided by the applicants to Your Honor via email. We were copied, and after we complained that they were misleading the court,
Okay.
keeping that evidence.
Well, I don't have that at the moment.
Yes.
I will. Do you have any?
So the evidence of that.
Just hang on a minute. Ms. Foley, do you have any objection to my looking at the transcript?
No, Your Honor. Although I should say that my learned friend's submissions are traveling far beyond a standard objection to the admissibility of an affidavit.
Absolutely. I would, though, take some of the submissions as submissions he will be making later on anyway, so.
Thank you.
The reason why I let them go.
So, Your Honor, let me read what I want to read.
I don't have the transcript yet, Mr. Kuksal. I'm just getting it.
You're welcome.
If it has been sent to someone that can get it to me, I don't know if it has.
I understand, Your Honor, that it was emailed to Chambers at 2.31.
Okay, well,
The beyond reasonable doubt.
someone will email it to me in a minute.
So, Your Honor, may I continue in the interim?
Yes, you may.
So what I will say is said in the transcript is that, on the 15th of May, Mr. Silva, who was acting on behalf of the Board and the Commissioner, or the Board specifically, actually made representations before Justice Bennett, and, in effect, said that some emails, and this is the direct quote that I'm reading, Your Honor, that some emails have been sent to the court containing material of allegations of sex states and social conduct of individuals who are not parties or witnesses. The individual in question to Justice Bennett is not a party or a witness. Now we have foreshadowed an application to be made formally in writing. After we had orally made an application that the applicant in that matter, which is the Legal Services Board, their solicitor, calls Westgarth Chambers, and the principals who have acted in the matter, Mr. Jared Heath, have committed a contempt of court in preventing Mr. Thomas from affirming an affidavit which was to be used as tendency evidence in the bankruptcy proceeding. And the substance of these matters are referred to in Mr. Flitner's affidavit of today. Now, the substance of the allegations to be made in the bankruptcy matter by Mr. Flitner was that Person 1 had solicited Mr. Flitner while Person 1 was working for a law firm called Hunt & Hunt, and also—
Can I interrupt again?
Yes.
It may be that Mr. Kuksal doesn't quite appreciate the need to be careful in saying things which might identify Person 1. He is clearly identifying relevant features that might be used to identify Person 1. And there is no need, given that Your Honor can read the affidavit once it's provided and he doesn't need to repeat these things in open court.
Your Honor.
That's upheld, or I agree, Ms. Foley. The other thing I'm struggling with a bit, Mr. Kuksal, is, what is your point arising out of the transcript? Proceeding is to prevent a contempt of court in a related proceeding. Does your proceeding?
The point is this, that the purported objective of this particular honor agree that that is the court's understanding of the purpose behind the—
Well, you don't ask me the questions. I think that the application is probably broader than that because it's also about abuse of process, as I understand it.
But how can one stop an abuse of process in another proceeding? That application has to be brought in that proceeding.
Well, Mr. Kuksal, just to go back a bit, I think we need to let Ms. Foley make her submissions, because this is going to the substance of the applications that are made today, and I think these are submissions that are better made when you are responding to her submissions about whether I should grant the application or not. Now, insofar as you have concerns about the affidavit of Mr. Heath, I can make a decision about that later on, so it doesn't necessarily. I will make a decision about admissibility of certain paragraphs of it later on. Okay, so—
Your Honor.
You can get on with the substantive matters that are before me.
Sure, I do not in principle oppose that, but I would like Your Honor to not rule about the admissibility of the evidence at all at this stage, and not sort of rule that the affidavit is generally admissible, except for paragraphs that Your Honor will later on stipulate because, in my submission, that would be an advance ruling on evidence made pursuant to Section 192A of the Evidence Act, without following the criteria that needs to be followed, and advanced ruling on evidence. So in my submission, if Ms. Foley wants to make submissions generally, without relying on specific affidavit material, then that is certainly a prudent manner of conducting the matter, because we need to understand what their core contentions are. But the two concerns that we have about the material are, 1, that if Your Honor is exposed to the intimate details, because of how the brain processes information, Your Honor cannot effectively and reliably take it out of her mind. I can refer to studies about this, and this was the basis on which Justice Bennett recused herself recently, the submission that I made on that front, so we don't want Your Honor to be exposed to allegations that are scurrilous and made without any basis in the affidavit material. The second concern that we have is to the extent that there may be, and again I'm not conceiving relevance, but to the extent that there may be some remote relevance of some issues in the affidavit, the court must first hear us about the balancing criteria in terms of the discretion that the court has to exercise, because the allegations that are made in the affidavit concern very serious allegations of a criminal nature, and they may affect the outcome of other proceedings as well. So you must hear us about that, and because of that, I say the court should not admit the affidavit at all. But if Ms. Foley wants to refer to them, some paragraphs that have direct relevance in her view as submissions, only because she doesn't want to pronounce those matters out loud and wants the court to read them, I will not oppose that. But I would not like the court to have consideration of all of the material or take any of the material as evidence at this stage.
All right. Ms. Foley.
Thank you.
Do you wish to proceed?
Yes, thank you, Your Honor. And the way that I'm proposing to proceed is that Your Honor will rule on admissibility of the affidavit later, but I will proceed to make submissions to Your Honor, for the benefit of the court and also for the respondents to understand the way that our injunction application is put. So I will proceed by taking Your Honor through the paragraphs of the affidavit that are relevant, if I can take Your Honor to paragraph 7 in the first instance. Now this is in Part B of the affidavit, which sets out the origins of the board's dealings with the respondents, which is part of the background to the proceeding.
Is this in the—
And Your Honor will see,
This is Mr. Heath's affidavit.
Your Honor, prejudicial material that I was objecting to Your Honor reading. This has no relevance to this matter.
Mr. Kuksal, we will never get anywhere if you don't let Ms. Foley finish saying anything, and I haven't even managed to clarify with her yet what part she wishes me to read. So Ms. Foley?
She's referring to 21.
Ms. Foley.
Your Honor.
Sorry.
Thank you. I'm referring to the affidavit of Jared Heath.
Yes.
Affirmed today, and if I could take Your Honor to paragraph 7.
Right. I have paragraph 7 in Part A, not Part B.
My apologies, Your Honor. It is Part A, Paragraph 7, which is really the beginning of the relevant background to the Board's dealings with each of the respondents, and Your Honour will see that from 2021, when some information was received by the Board, certain investigations and regulatory steps were taken.
We object.
In relation to...
We object.
I understand you've taken objection, Mr. Kuksal. You can make those later, okay?
I read this material for the sake of the recording, because we also suffer prejudice, Your Honour. They're preventing us from making allegations in open court. I do not want Ms. Foley to make allegations against us which are completely irrelevant to this proceeding.
Well, I think Ms. Foley is trying to tell me why they're relevant.
Well, so she shouldn't refer to those allegations and simply refer the court to the paragraph number in that case.
Could I be clear, Mr. Kuksal, and for Your Honour's benefit, I'm not reading out what the allegations were. I'm simply referring the court to the relevant paragraphs in the affidavit, and indicating that, as a result of the information that was obtained, various steps were taken by the Board. That is the relevant background in 21. Your Honour will then see, if Your Honour goes to paragraph 10, that certain regulatory steps were then taken by the Board, and those steps including the appointment of an external manager of one of the entities associated with the respondents. Following those regulatory steps, in 2022, an injunctive relief was sought against the respondents, and that's set out in paragraph 11 of the affidavit, to restrain them from obstructing the appointed external manager from exercising his functions. And ultimately, final injunctive relief was granted in the Supreme Court of Victoria by Justice Gorton, on the 1st of November 2024, to restrain the respondents from representing an entitlement to engage in legal practice, and also, in relation to Mr. Ansell in particular.
Your Honour, Ms. Foley is reading out the allegations. She's making assertions about factual matters in open court, whilst at the same time preventing us from relying on our evidence. This is not a fair hearing, Your Honour. This is completely...
Mr. Kuksal, I'm just not going to let you to continue. What Ms. Foley is reading out, to the extent that it's being read out, and I think she's actually summarizing it, matters that are available on the public record, either injunctions,
No, Your Honour.
were granted or they weren't, in 2023.
I accept that. But she's making allegations about associations between individuals and those entities.
I've heard no allegations in that regard. Now, Mr. Kuksal, I will have to ask you to let Ms. Foley finish, or at least speak.
Thank you, Your Honour. Thank you, Your Honour. And then in paragraph 15, Your Honour will see that final injunctive relief was granted in those terms by Justice Gorton in the Supreme Court. Now, that takes us then to what happened in 2022 and since 2022. The affidavit sets out in Part D a range of proceedings that were then commenced by the respondents against the Board, against the Commissioner, or its officers and employees since that time. And I won't go to the detail of it, but Your Honour will see, from paragraph 16 onwards, the number of proceedings that have been commenced, and which are relevant now to the injunctive relief that we're seeking. Part E is the threats that have recently been received, and I will explain those threats by reference to the affidavit and also their relationship to the proceedings. So to begin with paragraph 20, which is the first such threat that was received on the 7th of May, and it was an email that was sent to each member of the Board as well as to certain solicitors. And Your Honour will have as the relevant exhibits the letter and emails. We also have in then paragraph 23 the content of what was involved there, which, as you know, we have described as the Flitner Allegations. Now we have referred to person 1 already, Your Honour. We have also referred to another individual that was named in those allegations as person 2, and our pseudonym order will seek to cover both person 1 and person 2. We then had a series of further emails and correspondence. If I can begin with paragraph 26, subparagraphs A and B, which set out emails to the Federal Court, and also to the Supreme Court, which contained the relevant material. In subparagraph C, we had the filing of an affidavit in the Federal Court on the 14th of May. In subparagraph D, we had the email to the Federal Court. In subparagraph E, we have another email, and that is on the same date, the 16th of May, to the Supreme Court. So we have an escalation of conduct, seeking to file and put before the court in various ways, the Flitner Allegations. This then culminates, Your Honour, if I can take Your Honour to paragraph 29 to what happened yesterday, which is an email being sent to the chambers of Bennett J., and there was a Dropbox link, and that contained an audio recording of a phone call between Mr. Flitner and Mr. Kuksal, and in that audio recording, there is a discussion of the intention of disseminating and publishing the Flitner Allegations, including all through the media.
Your Honour, these are very scandalous assertions that are being made. Calm down. Your Honour, firstly, it has been misrepresented what the document is. The document was an exhibit to an affidavit that was filed. It is entirely improper for Ms. Foley to misrepresent the document without actually, if she used excerpts from the transcripts of the record, that would be one thing. I say the way in which she's summarizing the document is entirely misrepresentative. It's an evidentiary document that I have filed, exhibited to my affidavit, in that particular proceeding. If it is an abuse of process, it should be raised in that particular proceeding, not in a separate proceeding. This, by the way, is a classic abuse of process, by basically abusing the information asymmetry that exists, because Your Honor has just been seized of the matter and has no background in the matter. So instead of raising the matter before the appropriate judge in that particular matter, they're circumventing the process to sabotage us without the ability to file responsive documents and clarify the context to the court.
Well,
So Your Honor, I do not want her to summarize the content of evidentiary documents without putting it on affidavit material. Either she uses the original content or she swears to the facts that she's referring to in court, but this misrepresentative slandering of the respondent.
Mr. Kuksal, I'm going to have to ask you to just be careful what you say about what Ms. Foley is doing, because if, in fact,
I have an intention to disseminate material without proper basis, just so I can maliciously harm an individual, that is slander.
I beg your pardon? What Ms. Foley has done is referred me to a paragraph of an affidavit that says, She sent an email titled The Respondent's Affidavits and Authority. Sorry, at 9:33 a.m. on the 20th of May 2024, She sent an email titled The Respondent's Affidavits and Authorities to the Chambers of Justice Bennett, caused by Mr. Amor, Mr. Kuksal and Mr. Ansell, with a Dropbox link that I understand this is Mr. Heath's affidavit, contains an audio recording.
It's an assertion at this stage, it's not admissible evidence. What I'm saying is that Ms. Foley is first conceding that it's not evidence before the court, and then seeking to rely on it as if it is evidence before the court, which undermines the whole point of the objection.
Okay. The point of the objection, I understand your objection. As I've said, I will rule on it later.
Look, it's referring to it in open court and making allegations against me. The reason I am objecting to that affidavit is because it doesn't actually refer to the content of the document. It unfairly summarizes and attributes intention to the document, for which there is no basis, and it cannot be accepted as evidence at face value. And Ms. Foley cannot refer to it as if it were evidence at face value. So whatever she's saying in her capacity as a member of the bar, as submissions from the bar table. So she should not attribute any intention to me or use second-hand documents to refer to evidentiary documents filed in another material, in another affidavit. That's the objection, Your Honor.
Right. Thank you, Mr. Kuksal. Ms. Foley?
Thank you, Your Honor. And just to be clear, and for Mr. Kuksal's benefit, the relevant emails, letters, and also a copy of the audio recording are all exhibited to the affidavit. That part of the affidavit deals with the threats, and again to summarize, they're threats to file documents in a range of proceedings, threats to rely on this material in a range of proceedings, but also the event that happened yesterday, a further threat to more widely disseminate, including a discussion about disseminating to the media. So that is the background and the nature of the threats. We then, in Part F,
So just before you go any further,
yes.
So you say that if I were to listen to the audio recording which is annexed to the affidavit, I would hear the intention to disseminate and publish, including through the media. Is that it?
Context. Yes, Your Honor, and the particular journalist is named in that.
Right, thank you.
Recording. Your Honor, I refute that assertion. That assertion is entirely scandalous, and I invite Your Honor to settle this issue of fact by listening to the...
Right, thank you, Mr. Kuksal. You can rest assured I will be weighing up all of the evidence and submissions. Okay, Ms. Foley?
Thank you, Your Honor. Part F of the affidavit deals with the risk of harm in further circulating this material. We have focused, as the court would appreciate is very important in this case, on the well-being and the impact on our affected employee, Person 1, given the nature of the material and the allegations. But we have also, in Part G, described the impact upon the board's regulatory functions and its law enforcement functions. That is an important feature of this application, partly because we have a range of employees, of course, who carry out the work of the board, and what we have now is a situation where individuals are being targeted with these kinds of allegations, not just one individual in this case, but two, Person 1 and Person 2. That kind of conduct, of course, can have the ongoing impact on the board's functions and its ability to carry out those functions. But in the context of particular proceedings that are on foot, and this is of course the basis of the contempt and the abuse of process allegations that we make in our concise statement. The purpose, we say, is to prevent the board from being able to undertake its work properly, and to affect the proper conduct of those proceedings, including, for example, the intimidation of witnesses. So we say that there's a range of harm that might follow, and in the case of person 1 will follow from why the dissemination of the material in the way that has been threatened. That is the evidentiary material that is before the court. In relation to the principles Your Honour needs to have regard to on an urgent interim injunction application, there are two features. The first, of course, is whether there is a serious question to be tried, and the second is the balance of convenience. And I will just address Your Honour in relation to both of those. Firstly, the serious question to be tried. As the concise statement makes clear, the applicant alleges that the respondents are threatening to engage in conduct which we allege would constitute abuses of court processes, and that is multiple court processes, and also contempt of court. We allege that the respondents' threats have this character because they amount to harassing, intimidating, or otherwise placing improper pressure on a litigant in order to a. deter them from prosecuting or defending an action, b. deterring them from giving evidence in a proceeding, and c. influencing the evidence that they might give. In this regard, Your Honour, it is relevant that threats have been made in the context of extant litigation, and the allegations also have no legitimate forensic purpose, and we address that. If I may take Your Honour to some relevant parts of the concise statement to bear out those matters, if Your Honour has that there.
I do.
Thank you. So, if I can just indicate in the first instance, the extant legal proceedings, and this of course marries up to the relevant paragraphs of the Heath affidavit. So in the concise statement, paragraphs 12 through to 19 set out the relevant extant proceedings. We then set out in paragraphs 20 to 30 of the concise statement, the relevant threats that have been made. We then demonstrate how those threats relate to matters that have no legitimate connection to those exam proceedings. And, in that regard, can I take Your Honour to paragraph 36 in the first instance? And it says there that, to the extent the Flitner allegations concern alleged conduct by the applicant or its officers, employees, or agents, the relevant alleged conduct exclusively concerns Mr. Flitner, and does not involve conduct directed to, or concerned with, any of the respondents, nor their officers, employees, agents, or related parties. And then in 37 and 38, we set out the fact that neither Mr. Flitner, nor Person 1, nor Person 2, are parties to the extant proceedings, nor relevant witnesses, and that, in sum, the Flitner allegations are not relevant to any fact, matter, or circumstance in issue in those proceedings. So we say that these allegations simply have no legitimate purpose in relation to those extant proceedings. And our allegation is that the purpose is, in fact, by threatening reliance on those allegations to intimidate, to harass, and to bring improper pressure on the applicant.
Your Honour,
Then, Mr. Kuksal.
Sorry.
You will get your opportunity.
Your Honour, may I just quickly raise an objection about the thing here? It is asserted, as a matter of fact, that 1. The allegations are being made the way they're saying we're making them, and 2. That they have no relevance to the issues in fact in the proceeding, without the applicant even providing a copy of the originating motion filed in those proceedings, which sets out the issues being contested in those proceedings. So it is basically presumed that the court will take it at face value, that their assertion regarding the issues in contest in those proceedings are correct, without them even providing the originating documents to which those proceedings were commenced or the affidavits filed in those proceedings. So I say that that is a scandalous assertion, and it is unsatisfactory conduct from Ms. Foley's part.
I will ask you to withdraw that. All Ms. Foley is doing is trying to give me a summary as best she can on an urgent application. It's up to me to weigh what evidence I've got before me and what submissions have been made.
But, to ensure that she's not using court's compulsive powers, or she's not asking the court to invoke compulsive powers without proper basis, it is clear that she hasn't.
Mr. Kuksal, you will get an opportunity to make submissions in a minute. I would like to finish hearing from Ms., and then I will move to you.
Thank you.
Ms. Foley? Sorry.
Thank you, Your Honour. In the concise statement, we then, at paragraphs 44 and 45, set out in 44 what we say the conduct constitutes, namely threats to abuse the processes of the court, and threats to engage in conduct that would constitute a contempt. And then we set out the court's powers to grant the injunctive relief restraining that conduct. Your Honour, on the basis of the affidavit material that we've put before the court and the concise statement, we say there can be no doubt that the threats have been made, and Your Honour has copies of the relevant emails and letters and so on. And also no doubt that they have been made in the context of extant proceedings, where the material is being sought to be put before the court in those proceedings. I should also say that the originating motions in the extant proceedings have also been exhibited to the affidavit. So we say that there is ample material before the court to satisfy that first limb of the analysis, whether there is a serious question to be tried, which brings me then to the balance of convenience. As Your Honor is aware, this is an urgent interim injunction application, and all we're arguing about is whether or not the balance of convenience favors the granting of the injunction for a short period of time, until the interlocutory injunction application can be heard and determined. On the basis of the risk of harm to the affected employee, person 1, if the injunction is not granted being very high, we say that the balance of convenience favors the grant of the injunction. The nature of the harm is very significant, having regard to the content of the allegations themselves. And we say that the impact on the board itself as well, and its ability to properly discharge its functions, and have its own staff feel comfortable in the work that they do, without threats of this kind being carried out and disseminated to the wider public, is an important feature of this case, to be borne in mind. Once information of this kind is disseminated more widely, an important point is that it can't be wound back, the egg can't be unscrambled. So that's another feature of this case which is relevant to balance of convenience. We say that if the conduct is not restrained, the risk of quite significant harm to person 1, and also to the board, is very real. And looking at the other side of the coin, it's difficult to see any prejudice to the respondents if an interim injunction is granted, because all it will do is hold the position in place at the moment, that they cannot more widely disseminate the material that they're wishing to disseminate, and can't take further steps to put those documents before the court until an interlocutory injunction is heard and determined. So those are the bases for the injunction application. And at the appropriate time I can address Your Honor in relation to the precise orders that we seek, and also the pseudonym orders and the basis for those. I'm not sure if Your Honor would like to hear me now in relation to those, or a little later, but I can do so now if that's convenient.
I would like to hear from you on those. What I would also like to understand is where you say I get the power to grant an injunction in relation to the processes of the Supreme Court of Victoria.
Yes, so Your Honor, the way that we've crafted the injunctive relief that we seek is framed around preventing conduct, and that conduct might have an impact in relation to what the respondents are proposing to do in the Supreme Court, or, more broadly, in relation to the media. But it's not directly impacting, we say, the jurisdiction of the Supreme Court of Victoria. So if I can take Your Honor, perhaps it would make sense to make this submission in relation to the orders themselves.
Okay? Just let me get those up if you will, please. I've been sent them now, I think. I have them here in hard copy, the draft orders.
Thank you, Your Honor. Thank you. So if I can just indicate, we seek in the first instance, where the primary relief we seek is paragraph 1A, paragraph 1B is an alternative, and then we also seek 1(1)(c). Paragraph 2 is an alternative to Order 1. So I might just start with our primary position. So looking at A, Your Honor will see that it's framed as engaging in conduct that is calculated or has the tendency to intimidate, harass or otherwise bring improper pressure to bear on the applicant in respect of the conduct of any legal proceedings, such as to deter them from prosecuting, defending, acting in, and so on. So it is broadly expressed, but it's not directed to particular court proceedings happening in the Supreme Court by its terms. It's simply addressing conduct of that kind, and there are cases that we have relied upon to support the framing of injunctive relief in that way.
Are you able to give me
and if Your Honor would be assisted?
Yes, please.
Yes, thank you, Your Honor. The first case is Basetech, BASETEC, Services Pty Limited v. Leighton Contractors, No. 2, 2015, FCA 762. And we have molded paragraph 1A of our orders in the same way that the relief in that case was framed. The second decision is Registered Clubs Association of New South Wales v. Stoltz, STOLZ, No. 2, 2021, FCA 1418. And the third case that we rely upon is YNZ VW 2007-70, NSWLR, at 377.
Thank you.
We seek, reads, thank you, paragraph C, which is also part of the primary relief that without limiting Order 1A, it would prevent the respondents from communicating to the applicant or its officers, employees or agents, whether directly or indirectly, any threat to engage in conduct, the subject of Order 1A. And then we've framed an alternative order, Your Honor, as you will see in paragraph 2, which is focusing in particular on the uploading, disclosing or dissemination of the Flitner allegations. And then also in B, communicating threats to engage in the conduct the subject to 2A, so that's a narrower form of the order. We of course are seeking the primary relief, but if Your Honor is concerned about that, we have framed a more narrow form of the relief in paragraph 2.
And in terms of the
Order 2, Your Honor.
Sorry, Ms. Foley.
Sorry, Your Honor.
In terms of your Order 1,
Yes.
1B is an alternative to 1A.
Yes.
What's the distinction there?
Again, it's focusing, instead of conduct described more broadly, by reference to what it's calculated to do, or has a tendency to do.
It specifies,
It focuses in particular, yes, on the uploading, disclosing, disseminating or otherwise of certain content.
right, okay, yes.
We also seek the order in relation to paragraph 3, if Your Honor has that there, and this is, again, framed simply until the hearing and determination of the interlocutory application. And it's preventing the reference to the Flitner allegations or their substance, and refraining from re-uploading, re-disclosing and so on. So again, it's very much focused on the Flitner material, and just holding the position ahead of any interlocutory application. We then have the confidentiality orders that I've referred Your Honor to. Order 4 is to preserve the confidentiality of certain material that has found its way already onto the court file. And Order 4 is in relation to material that has been filed or is in relation to this proceeding. Order 5 is an order that prevents the publication of the allegations and of any document referred to in Order 4, so it's really ancillary to Order 4. The order that we seek are in Order 6, and they relate to Person 1 and Person 2, who are the two employees who are named in the Flitner allegations. And then Order 7, and Order 8 concerns service by email, and we confirm that we had served the respondents by email, rather than in the usual way because of difficulties that we had had in the past with service, but also to make sure that they were notified as promptly as possible of today's hearing.
Your Honor.
And then,
Your Honor, there's a threat.
You can object.
There.
Yes. Yes, Mr. Kuksal?
Your Honor, there are assertions being made without any proper basis, and I'm just putting to the court that there was no effort made to serve us in person. There's no evidence that there was any difficulty in serving us in person. We have been very prompt in responding to the applications that have been served to us. So there's no proper basis to assert that there's any difficulty in serving us in person.
All right. And I'm not setting any store on that. You're all here. Okay? So as far as I'm concerned, you've responded to the email service. Okay. Ms. Foley.
Thank you, Your Honor. And then, finally, I will just note Orders 9 and 10, which relate to the bankruptcy proceeding, and the reason why we have included those orders is because material was in fact filed in the bankruptcy proceeding that contained the Flitner allegations, and we have issued a separate
interlocutory application in relation to that material, but we've included it here, in this proposed order, and would hope that Your Honor could deal with that as well. Your Honor might be aware that Bennett J., after hearing the matter last week, has recused herself and that matter will now be transferred to another judge. What we wouldn't want to have happen in time, this same material that is the subject of this application, somehow slips through the cracks and is able to be accessed on that court file. So we've included an order of a similar kind to the orders that we're seeking in this application, in the orders that we've sought, just to protect the position in relation to that proceeding, as well. Right, thank you. Is that your submissions?
Yes, Your Honor.
Can I just ask you one other question, Ms. Foley? It occurs to me that some might think that these allegations are ones that would be better referred to the police. Are you able to address me on that?
Well, I am here representing the board.
Yes.
And the relevant employee will of course receive her own legal advice, and I don't seek to be heard on what steps
she has taken.
That person may or may not take.
That's fine. That's okay.
She will receive her own legal advice.
That's absolutely.
And we certainly feel, yes, and we certainly feel as the board, that regardless of any steps that the affected employee wishes to take, we have a responsibility, as the employer, to take all relevant steps to protect her health and well-being, particularly given that it is her employment role which has put her in this position, as well as the second relevant employee, particularly given that it's all related to, as I've made submissions about, extant proceedings involving the respondents and the board.
Thank you. Thank you very much, Ms. Foley. Okay. Mr. Kuksal, how long do you think you will be, Mr. Kuksal?
Well, Your Honor, it depends on how quickly Your Honor understands certain matters, but there's a very wide net that has been cast, and I think I need at least a couple of hours to address the court about the relevant matters, and I need to rely on some evidentiary documents. I am prejudiced in the sense that we have not been able to file the evidence in relation to the proceedings that are referred to as the extant proceedings, and the matters in dispute in those proceedings. The relevant documents have not been presented to the court, So if the court accepts what we're saying at face value, without us having to rely on evidence, then I will need at least 2 hours to go through the matters that I need to go through. But I would like to flag that there is an unfair prejudice from the fact that we haven't been able to file evidentiary documents on which we would have relied to make the assertions that I'm going to make.
Right. Well, what I'm inclined to do, first of all, I will just find out, do Mrs. She or Mr. Ansell wish to be heard?
Your Honor, if I may address the court on their behalf. Miss She is with me, and I'm not sure if you can hear her, but they would basically supplement what I say, but I will make the predominant proportion of the submissions. So they may take maybe another half an hour to address the court, but I will be addressing. Yes, you can.
Right. So what?
Sorry. I do have quite a lot to say. It depends on what Mr. Kuksal will because of how quickly this matter has come on board. Principal, we would oppose cover, and that I don't repeat him. But I wouldn't know what he will be covering. But I do have quite a lot to say in response to the allegation that was just made against us.
Your Honor, we've not had time to coordinate the submissions. I will try and cover the majority of the submissions that I can anticipate will be raised. And then, if Miss She and Mr. Ansell say anything additionally, I think that it wouldn't be twice as much time as I'm taking. It would be a small proportion of it in my understanding.
Okay. Well, there's a couple of things that arise from that. The first is that, if you wish to have some time to put material on, the way to do that would be to give undertakings for a couple of days, or however long it is you think you need, to put material on.
Well, I think it would be absolutely improper, and in this infringement or abrogation of our constitutional right and our access to the court, we have been preparing to commence contempt proceedings against the board in the Supreme Court of Victoria. Ms. Foley has just indicated to the court that this is an underhanded tactic to prevent us from adducing the evidence in the Supreme Court. The Supreme Court, we have put them on advance notice of our intention to commence the proceedings of the Supreme Court. We have been preparing for it for quite some time. These are contempt proceedings, which basically assert that the board is using the sort of tactics that it is actually accusing us of using, and we urgently need relief, Your Honor. We have been oppressed, we have been persecuted. What they're trying to do is, effectively, prevent us from surviving the onslaught that they have improperly brought against us. These allegations are purportedly being made on behalf of the employee. The employee is not represented. The employee is not a party to the proceeding. All the bases that Your Honor heard right now were, essentially, different forms of the same expression, that the employee would be irreparably harmed. The employee is not a party to the proceeding. The allegations that are made, the board is aware of them since 2024. The reporter that Ms. Foley is referring to, Your Honor, there is another issue with this matter as well. It is whether or not any undertaking would place us under unfair prejudice. There is a reporter who is named in the recording. It's not a reporter that I have contacted. It's a reporter that has already given an interview to. It's a reporter from Australian Financial Review, who is currently doing an expose about the board, and another person who I don't wish to name, because they're not a party in this matter, a businessman, who it is alleged may have corrupt dealings with the board, and what they are trying to do is somehow prevent. Mr. Flitner refers to his interview with that reporter. It's not a reporter that I have contacted or spoken with, and he suggests that I also contact the reporter in relation to my experience and the experience of other people of which I have knowledge. We would not give undertakings that prevent us from. We've already contacted members of Parliament, or initiated communication with them. We have meetings organized with them. This is about the corruption within the Legal Services Board, and if our obligations are completely baseless, they have proper recourses. We will not give undertakings to. We have, Your Honor, for 3 years, our businesses have been disrupted. We have been prevented from accessing the court in various different ways. Now we have gathered evidence of all of those matters, and we've prepared diligently and with extreme dedication, and we have matters lined up of which they have now learned the developments that can hold them accountable, and they're coming to the court at the last minute, ambushing us. And what undertakings would the court require us to make that we won't commence proceedings in the Supreme Court to Billikay's matters?
The undertakings that would be required are the ones about which I suspect the applicant's firm wrote to you seeking.
Yes. No, Your Honor.
Undertakings.
We will not. We will not file evidence in the court. It's absolutely scandalous. Your Honor is not aware of the issues of the various proceedings.
Mr. Kuksal, all I said was that, if you wanted to put evidence on, you could give short-term undertakings, and then some of the urgency would go out of it, and you would have time to put evidence on.
We believe we are in...
Well, you're not seeking any relief here. You're not seeking any relief.
No, Your Honor. What? We are seeking relief through the Supreme Court in relation to the contentious perversion of the course of justice by the board. What they're...
Right. Well, I'm not going to get into what's happening in the Supreme Court. You've told me you won't give undertakings. That's fine. What I am going to do, though, now is observe, first of all, that Miss Foley was able to make her submissions in less than an hour and a half. So the maximum that you and Miss Shi and Mr. Ansell will have will be 2.5 hours, which is much more than Miss Foley, and that is an acknowledgement that you are litigants in person, as opposed to represented. I am also going to now,
Your Honor.
stand the matter down for about 15 minutes for everybody to have a break, and I'm also going to suggest to you, have you received a copy of Mr. Heath's affidavit?
I have, but we wish to file affidavits that were filed in the Supreme Court, so we can put the issues in those proceedings before the court.
Well, we're here now on the application of...
Well, we will file them within the next 15 minutes, Your Honor.
I beg your pardon.
We will file those affidavits. Within the next 15 minutes, we will file the affidavits that were filed in the other court so the court can actually decide the matters on evidence. What they're trying to do is use this court to prevent us from filing documents in evidence in other courts that are beyond the jurisdiction of this court by having this court make deceptively improper orders that would prevent us from filing evidence in the Supreme Court.
Well, I think
Your Honor,
I think if you listen to what Miss Foley said, the orders that she seeks to have made are in fact not trying to stop you filing at large in the Supreme Court, just not filing the evidence that, let me be very broad, is contained within the Flitner Allegations.
Yes. And, Your Honor, those Flitner Allegations are central to the case that we're making. Because what is alleged to the Flitner Allegations is that the Ms. McLeay, the Legal Services Commissioner, does not meet the character requirements for the role that she has or to be a member of the profession. Because, despite knowing that Person 1 was working as an unregistered sex worker who solicited Mr. Flitner, Ms. McLeay permitted Person 1 to basically make determinations about external intervention matters related to Mr. Flitner's practice. And when she became aware of Mr. Flitner's objections to those matters, Ms. McLeay essentially threatened him improperly with imprisonment if he opened his mouth and then instituted a number of other adverse actions against him, whilst maintaining that there was no conflict. 1. Ms. McLeay acknowledged that she was aware of Person 1. Your Honor, this is the substance of the contempt that's being alleged before the court. It is tendency evidence that we are using against Ms. McLeay and Person 1, because those people have taken adverse actions against us as well. And what we are possess the character commensurate with manifesting public sector values, and the being part of an extended pattern of conduct. Saying, is that these matters, in addition to the other evidence that we provided, further corroborate that those people do not meet the character requirements that members of the profession must have, and that people acting in administrative roles within the Australian government must possess, as laid out in the Public Administration Act, the public sector values. What we're saying is that they do not should draw an inference in relation to the conduct that we have experienced.
Right. Well, Mr. Kuksal, you're now giving an awful lot of evidence from the bar table. As I said, I'm going to stand the matter down. Now that you...
Affidavits that are before the court so the court can understand how we wish to argue that extended pattern of conduct, how the flippant allegations complement what we are alleging against those individuals.
Right. As I've said, Mr. Kuksal, I will hear from you fully, but it's going to have to be confined to 2.5 hours. I'm now going to stand the matter down for half an hour, which will give you time to file the affidavits that you say you want to file, and they will have to be filed in this matter. And also I would suggest you have a look at Mr. Heath's affidavit, because it does annex a number of the originating processes that you say I would need to have regard to.
Yes. Then, provide the court with further documents. Thank you.
Right. Okay. On that basis, could you please stand the matter down for half an hour? Okay. Have we everybody back? Ms. Foley, I think I can see you. Can I see? Is that Mr. Kuksal? The pictures are so small.
Yes, Your Honor.
Mr. Kuksal is there. Is Miss Shi there?
Miss Shi is with me, Your Honor.
All right. Mr. Ansell?
Yes, Your Honor. I am here.
Okay. Thank you. All right.
Thank you.
I'm sorry we took a bit longer. I was waiting for your material to come in, Mr. Kuksal, and I'm not sure whether I've got anything yet. But we need to get moving. So...
Received it? Your Honor, the material has been sent to the court. Have you not?
I've received an unsworn affidavit of Ms. Shi, but I don't quite know what the attachments are, because they seem to have been sent via Dropbox, which we don't usually have access to. What are the answers?
So, Your Honor?
Yes.
All the exhibits that we filed in federal court proceedings have been through Dropbox, and the registry normally accepts exhibits through Dropbox. Everything we filed up until now.
The registry may not. Whether they come to my chambers in Dropbox is an entirely different matter. There are a whole lot of steps between the registry and me. Anyway, your point is that
This is interesting.
all the and shears are the material filed in VID 222 2025.
That's right.
Right. Okay, thank you.
Ange mystics, she has now affirmed the affidavit, so she will be able to provide a sworn copy of it imminently.
Excellent, thank you.
Now I also want to confirm that the court has received the exhibits to Mr. Flitner's affidavit, or the 5 and shearers to Mr. Flitner's affidavit.
To it, I don't think. No, I don't. I've received Mr. Flitner's affidavit. I don't have any attachments.
Your Honor, there were 4 electronic folders that were annexed, and 1 document that was annexed as Anshear 5.
Sorry. You will have to repeat that.
There were 4 electronic folders annexed as Anshears 1 to 4.
Electronic orders, did you say? Sorry, it's very distorted.
Folders. Folders.
Folders. Thank you. Sorry, the sound is quite distorted again. So 4 electronic folders and
1 document.
saying. Right. And how are you proposing to get this affidavit?
There's been 1.
He has sworn this in this proceeding, has he?
That's right, yes.
Right. Okay. Have you?
It's sealed by the registry.
Sorry?
Documents. It's been sealed by the registry. The registry has accepted the...
The applicant got a copy of this? Right. Well, I don't have a sealed copy. But I've got a copy.
Yes.
Right. And in terms of the ansheres, I will just have to have a chat to my associate to see if we can get those. Are you there, Mr. Kuksal? Someone is
Yes, Your Honor.
getting into the drop boxes insofar as they have come the registry, and will try and get them to me in due course.
Yes, Your Honor, there is a lot of material. There is a real prejudice to the respondents in circumstances where the court hasn't had an opportunity to go through the material, and I suspect I will waste a lot of time in waiting for Your Honor to get access to documents and so on. I propose that the court adjourn the matters to tomorrow morning. There is no difference that a few hours will make, but this is not going to be a fair hearing, as far as the respondents are concerned, because what the applicants are asking the court to do is extraordinary, it's unprecedented, and the way in which they're doing it is most unsatisfactory. The court also has to consider that the alleged threat that they say we have made was made on the 7th of May, Your Honor, the 7th of May 2025. It took them 2 weeks to come to the court arbitrarily, and then they came to the court in a way that was meant to ambush the respondents. They have filed a bunch of material without putting us on notice that they're producing that material. They sent a very improperly disguised letter, and the letter itself, Your Honor, said that before taking any further steps, they will foreshadow matters to the respondents. It was not indicated to the respondents that they were applying for proceedings at the time, and the letter, the reasons that were stated in the letter, it would have been significantly expanded upon, so this is an ambush. We weren't served a copy, a draft copy, or signed copy, or anything of Mr. Heath's affidavit, until it was by the registry. There's a lot of material in there. I haven't even had the opportunity to read the affidavits, by the way, because I'm focused on making sure I can put all the material that I will rely on before so there is no satisfactory explanation for why they waited 2 weeks since the 7th of May, and are now ambushing us in this manner. I haven't eaten anything the whole day, and I'm not in the best of states in terms of presentation of the matter. Mr. Ansell was supposed to be at a venue where he could attend the hearing properly, but because of the abruptness with which the hearing was organized, he's basically, bunkered in a place where he's attending on his phone. This is unsatisfactory, Your Honor. We're not getting procedural fairness, and if there were...
Until tomorrow, is that correct? The long and short of it is that you're seeking an adjournment.
I'm saying we must at least get until tomorrow so the court has the material organized and so we can also read the material that they have filed and so we're not, presenting the matter in a haphazard and completely disorganized way.
Right. I will hear from Ms. Foley as to her attitude towards that.
Thank you, Your Honor. Your Honor, as Your Honor is aware, this is an interim injunction application. We have no difficulty at all with the interlocutory injunction application happening at a time which would afford the respondents adequate time to put on any material they like, including written submissions if they wish. The question is how we maintain the status quo and protect the position in particular of Person 1 and Person 2 in the meantime. If the respondents are willing to give an undertaking in the form that we have provided to them in correspondence, then of course we would be content with an adjournment of this interim application until tomorrow, or if the court were content to make the interim orders until tomorrow. However, one option of course is that the interim orders are made, and the hearing is timetabled towards an interlocutory injunction application.
Right. Are they your submissions, Ms. Foley?
Yes, Your Honor.
Thank you, Mr. Kuksal. In reply?
Your Honor, that is absurd. The first matter is for the courts to determine whether it has jurisdiction in this proceeding. And, besides the authorities that I have already brought to Your Honour's attention, which, by the way, the counsel for the other side made no effort to advise the court about, the court also has to consider the authority of Thomson Australian Holdings Pty Limited v. Trade Practices Commission and others. The citation is 1981, 148 CLR 150. Now, Your Honour, what happened in that matter was that the parties were seeking an injunction in relation to a particular matter covered by the Trade Practices Act, and the injunction could not be sought under the Trade Practices Act because of technical reasons. So then the party, essentially, invoked the courts, or sought to invoke the court's jurisdiction under the Federal Court Act, to say that the court has inherent jurisdiction to make an injunction anyway, and on that, what the court clarified in that proceeding, this is a High Court matter, is that where the injunction is in relation to a specific subject matter, Judicature Acts, or the authority, the power that is set out in Judicature Acts, is not helpful in guiding the court's discretion. It's the acts and the laws that cover the specific subject matter.
Making broad. Mr. Kuksal, are you responding in relation to the adjournment or
Yes. No, I'm...
overnight, is that it? So what you're saying is, you won't give an undertaking.
Yes. And I'm also saying, in respect of what she's saying, that the court should make an interlocutory order by itself. I'm saying that the first thing that the court has to consider is whether or not it has jurisdiction, whether or not an appropriate matter is brought before it, and the factors that govern its jurisdiction. I haven't addressed the court about those matters yet. What Ms. Foley has said is that she has got to address the criteria that go into the making of interlocutory orders. The first criteria is whether or not they have a tenable case. The court hasn't yet determined whether or not they have a tenable case. The court hasn't determined that they can ever be successful, even conceptually, at achieving the orders that they must achieve. The second matter is the court has to consider whether or not the injunction that is sought will have any utility, whether or not the material that she's seeking the court to prevent the dissemination of has already reached other people, because it is fundamentally a matter that brings the administration of justice into disrepute if the court makes orders that are unenforceable. The court needs to hear evidence about that, which we intend to give. The third matter that the court needs to consider is the balance of convenience and the case of justice. Whether or not it would be just if all of the other things are there for the court to make such an order or not, it is exceptional that she's basically rushing the court into making extremely, I could not believe that the orders that were being sought in, which, admittedly, would prevent the respondents from even uploading documents to the registry of the Supreme Court of Victoria, because they contain certain allegations that the applicants considered to be not worthy of being made. So I think, Your Honour, we cannot be prevented from filing documents with the Supreme Court. We will not give an undertaking of that sort, and I think the court has no jurisdiction to prevent us from accessing various courts. It's a constitutionally protected right. It's also in the Judiciary Act, Your Honour. If I may refer the court to, let me just bring up the specific section, Your Honour. So, Your Honour, Section 64 of the Judiciary Act essentially sets out that every party, I'm just bringing up the document. Section 64 says that the parties before the court have equal rights. This is in relation to the government, the executive, and the subject. Now, I can get the specific section for the court, but essentially, the Constitution. This is set out in the authority of APLAV Legal Services Commissioner, and the citation is 2005-219 ALR 403. And in that authority, basically, the High Court had ruled that regulations that had authorized the Legal Services Commissioner in New South Wales from essentially adopting rules that would have prevented people from contacting or discussing with lawyers matters that would have resulted in the commencement of proceedings were unconstitutional because they sought to inhibit people's access to the court. And the specific sections that they've referred to of the Judiciary Act are Sections B, 55A, 55B, 55D, and 78 of the Judiciary Act. They're on that right. That's what the High Court had said, that those sections of the Judiciary Act effectively require unimpeded access to the courts, and any regulation or legislation that seeks to prevent people from accessing the court or inhibits them in any way is effectively in violation of the Constitution of the Commonwealth. Now, what Ms. Foley has admittedly asked Your Honour to do is to prevent us from relying on evidence. What she says would be an abuse of the court process in that court, but instead of, what she's effectively doing is asking Your Honour to legislate. The legislature has made no provisions to prevent people from filing evidence of any sort. Once the evidence is filed, it then invokes the jurisdiction of that particular court to decide whether, firstly, the has to accept the document, and they have to check whether or not it scandalizes the court in any way. Only if the registry finds that the document does not scandalize the court, then it's sealed, and then they have the possibility of asking the court to have it struck out on other grounds. What Ms. Foley is asking Your Honor to do is to make orders that would in effect have create the circumstance where, as litigants in current and prospective proceedings, if the respondents were to rely on some evidence, they would be committing contempt of this court. That is extraordinary, and it's an improper. This is in itself a contempt, because they're effectively seeking to stop us from suing them on matters that have been foreshadowed. Such an injunction should be sought in the respective jurisdiction, and not in this jurisdiction. And I don't even think it can be sought as an injunctive proceeding, as a separate injunctive proceeding. It needs to be sought in the same proceeding. I also bring rule, Your Honor, if I may just bring this rule to Your Honor's attention.
Mr. Kuksal, we can't hear you.
To that, Rule 42.11 of the Federal Court Rules. If Your Honor has access. If a party alleges that a contempt has been committed by a person in connection with a proceeding in the court, an application for the punishment for the alleged contempt must be made by the party by an interlocutory application in the proceeding. Your Honor, must be made. This is 42.11 Federal Court Rules 2011.
Yes, Mr. Kuksal.
And, Your Honor, this matter was canvassed before Bennett J. It's in the transcript, what the other side had sought to do. We had made an application that the Legal Services Board, their solicitor, and their solicitor's principal solicitor, Mr., were committing contempt of court. I've made the application orally because when the contempt had taken place it did, but there weren't 3 days left between that day and the hearing. So pursuant to Rule 17, I made an application orally, and I had sought to rely on the evidence, which they're now seeking to have struck off from the registry. And what the other side had said was that application for contempt should be brought as a separate proceeding. Now this was relevant because Bennett J. was considering Her Honor's recusal from the matter, and it was critical that Her Honor conclude whether or not she would have to hear the contempt application before deciding on the recusal. Because Her Honor's view was that, if she had to hear the contempt application, she would have to hear evidence from a witness who was a former client. In the end, Her Honor determined that there was, only after hearing contempt application, could the court determine whether or not it was proper.
Clear. Mr. Kuksal, are you still pressing for an adjournment? I'm just not.
I am pressing for an adjournment, but what I'm saying is that the court cannot grant interlocutory orders to them, because the matters that the court needs to be satisfied of before granting an interlocutory order are not matters that the court can be satisfied of without hearing us. We're saying that it's unconstitutional. And one final matter, Your Honor, if I may raise your attention, in terms of the legal principle involved. This is the authority of R.V. Gray, ex parte Marsh. I'm just bringing it up, Your Honor. So in R.V. Gray, ex parte Marsh, the citation is 1985 157 CLR 351. What had happened in that matter, Your Honor, was that there was a matter before the federal court, and there was a prerogative relief sought in the High Court, on the basis that the federal court did not have jurisdiction to hear the matter. A number of judges in the majority clarified that the federal court did not have jurisdiction, and Brereton J. set out the principle this way. What His Honor said is that, when a matter is before the court effectively has two jurisdictions. The first jurisdiction is to determine whether or not the court has substantive jurisdiction, and that is when the court hears both parties to see whether or not substantive jurisdiction can be invoked by the subject matter. After the court determines that it has substantive jurisdiction, can it go into the substance of the matter? So what I'm saying to Your Honor right now is that we cannot present the case in a fair manner because of the ambush tactics of the board. They have provided no explanation to the court about why they waited since the 7th of May to bring this matter to the court, without warning to us. The first time we were put on notice was at 8 p.m. last night, Your Honor, and we were given until 9 a.m. this morning to basically agree to undertakings on the basis of reasons that are much narrower than the basis for this application before the court. We were also promised that before any proceeding is commenced, we would be put on notice, we would be given further notice in the letter. This is common ground. This is not a contested fact that this happened, and, on that basis, the clean hands doctrine, Your Honor, is relevant. They are not coming to the court with clean hands. They have unnecessarily delayed the matter. We first, Your Honor, if Your Honor looks at the letter of the 7th of May that Mr. Ansell had sent to the board.
What page is that, please, of the exhibits to his affidavit?
Maybe Ms. Foley can help me with that, because I'm not familiar with the affidavit yet. Ms. Foley, can you assist me with that?
Your Honor, It begins at 4 of 59 of the confidential Exhibit 2.
Opening it as well. So I have the... Okay, so, Your Honor, I'm going to open it as Your Honor is...
I don't have that at page 4 of 59. Sorry.
I'm still trying to look at the affidavit, Your Honor.
I have confidential Anne Shear JRH2 at page 4 of 59, and
That's the one.
is that the letter?
Sorry.
Mr. Kuksal is referring to a letter.
That is,
An email, I beg your pardon.
as I said, that is what is being referred to, as I understand it.
Sorry. Which page? I have a 154-page document, PDF.
Right.
Which page of that is it?
I'm looking at confidential Anne Shear, JRH2, and it's marked at the bottom in the center 1 of 12, and on the right-hand side 4 of 59,
Okay.
and it's dated at top the 7th of May.
Yes. Your Honor, that is the email, in fact, that I'm referring to. It's page 98 of 154 of the PDF. Now, Your Honor will note that this was sent on the 7th of May 2025. And the second thing that I would like Your Honor to note is that it says, foreshadow proceedings and applications against the LSB officials. So we've been preparing since the 7th of May for the foreshadowed proceedings and applications. And it says, Your Honor, that, so this was a notice. Your Honor, this was a notice given pursuant to Section 97 of the Evidence Act to put the board on notice that we would rely on tendency evidence. Okay. That was the purpose of this document, and it has been clarified before Bennett J. Bennett J. in fact asked us if we had put them on notice, and this was the document that was relied on for that purpose. Now, Your Honor, if you go to paragraph 5 of that document, which is page 101 of 154.
I've got paragraph 5.
Okay. So it says, the additional evidence will include an additional affidavit sworn by me. That's 5.1.
Yes.
And if I skip to 5.2, an affidavit affirmed by Mr. Thomas Christian Flitner. That's the affidavit that you have before you today, Your Honor, through which he will give evidence of his personal experience of the conduct stipulated above. So this is how it's tendency evidence, directed at him by some of the alleged contenders, in part, to prevent him from raising public interest complaints regarding the corrupt conduct and moral turpitude of various alleged contenders and alleged corrupt officials. And then, if Your Honor reads 5.2.1, Person 1 solicited him in or around June 2019.
I can read them.
Okay, great. Now, Your Honor, if you refer to the footnote 14, okay, this is 5.subparagraph 5.2.4. In email correspondence between 9 and the 19th of April 2024. Your Honor, Mr. Alex Wolfe, acting on behalf of the LSB and Ms. McLeay, admitted to Mr. Glenn Thexton that Ms. McLeay was fully apprised. And footnote 14 there. As stated by Mr. Wolfe, in an email to Mr. Thexton, in an email at 12.17 on the 12th of April 2024, fully apprised of Person 1's interaction with Mr. Flitner in 2019, including, whatever it says there. I'm not reading it because of what Ms. Fawley had requested, and, in overseeing the external intervention into his practice. And then, 5.2.5, despite her knowledge of the matters referred to above, in respect of Person's role in the external intervention into Mr. Flitner's practice, Ms. McLeay found at the time that, and footnote 15, as stated by Mr. Wolfe in an email to Mr. Thexton at 12.17 on the 12th of April 2024. Now that email chain is also exhibited in the federal court. It's before Your Honor, exhibited to our documents which you haven't received from the registry yet but we've filed. Now what is said is that Ms. McLeay stated to Mr. that there is no conflict of interest and there will be no further investigation into the matter. So I run a non-profit, Your Honor, that gives people a platform to raise allegations of corruption against the government. And I'm particularly focused on raising those allegations against the Legal Services Board and on collecting evidence to use in support of an allegation of systemic corruption at the Legal Services Board. Those documents were provided to me 1 year later after they were raised, through the non-profit. Mr. Flitner has given evidence about that today. It's in Mr. Flitner's affidavit that he contacted, that a member from his group contacted Mr. Ansell, who's an officer of that non-profit, after he came across that non-profit's publications against the Legal Services Board's corrupt conduct. And then they came forward to give us that evidence, and we've been preparing to commence proceedings in the Supreme Court. And now that we are almost about to launch those proceedings, they've come to ambush us with that. Now I also note, Your Honor, that in the same letter Mr. Ansell had, if Your Honor those two, page 108 of 154.
Is this the confidential Anne Shear JH2?
Yes, page 108 of 154 of the PDF.
Right. So what page of that bundle is it?
It's 14 of 59.
Thank you. Yes?
Paragraph 31. Although I'm not including the LSB members as defendants in the contempt proceeding, I intend to include them in all correspondence with the LSB going forward, and take appropriate action if it becomes so on and so forth. And then what it says here is that, please advise, paragraph 36, Your Honor, next page. Please advise by noon tomorrow if you have any concerns about the publication of the information, clearly stating the legal basis for your objections. Okay? No correspondence was sent to us. This is a common ground. This email was sent on the 7th of May. Apparently it was so earth-shattering, and would undermine the administration of justice, to the extent that one court has to injunct us from commencing proceedings in any court in this country. But nothing was done on the 2nd of May. The only reason something was done yesterday was because yesterday there was evidence put before the court that a reporter is already onto the matter because Mr. Flitner has. That reporter had contacted Mr. Flitner in relation to a different matter, which connects with the Legal Services Board, and Mr. Flitner offered that reporter's number to me during that conversation. What I can undertake, Your Honor, is that no explicit material or the videos would be published online, because we have no intention of doing that. I can absolutely undertake that. We intend to give the content to IBAC though, because they need to be able to verify the content. But I can undertake that apart from the IBAC and VPSC Victoria Public Sector Commissioner, because the employment of Ms. McLean and Person 1 is governed by Public Administration Act, and VPSC is the body that has to see whether or not they're complying with their obligations. Apart from those two agencies, we will not give the content to anybody else. I can also indicate that if IBAC does not investigate the matter, then we would have to take the matter to IOV Integrity Oversight Victoria to complain about IBAC, and then ultimately to the Parliament. But apart from government agencies, IBAC and VPSC, and eventually IOV and the IOC, at the Victorian Parliament, we have no interest in having anybody else have access to the material, including journalists, Your Honor. I would not give the material to any journalist. I can undertake that absolutely. But any other matter that they're seeking undertakings in respect of, it is absolutely improper for them to seek those undertakings, and I don't know if the court can compel us to even give an undertaking in respect of the undertakings that I'm offering to give, but I will give it voluntarily without the court needing to compel us to, make sure that the court is unconcerned about our motives. So we have a simple objective in this. It is to allege that the Victorian Legal Services Commissioner is not fit for the role that she currently occupies, because of the way in which she has permitted serious allegations of improper and corrupt conduct, as those terms are defined under the IBAC Act and the Public Interest Disclosures Act, to go uninvestigated, and because of her knowledge of persons that have engaged in conduct that brings the profession into disrepute to continue functioning in their roles in high-profile, publicly visible roles where they make decisions about the integrity and the character of other lawyers. And Person 1, Your Honor, has taken adverse actions against me, and against my colleagues, other respondents. I have evidence about that. It's exhibited. So Person 1 is the head of the External Intervention Division at the Legal Services Board, and was responsible for decisions in respect of the retroactive non-renewal of Mr. Ansell's practicing certificate. Person 1 communicated that decision to Mr. Ansell, and made other adverse orders that affected my business and Mr. Ansell.
Your Honor, can I interrupt because, again, my concern is that the respondents are indicating information to the court in this open setting that is likely to identify Person 1.
Your Honor, you can see my intention. I have tried my best to not give any indication unless it is necessary for Your Honor to be apprised of the matters that Your Honor must be apprised of, in order to basically see through the thin veneer of misleading information that the applicants are putting before the court, exploiting the fact that they are not giving the court enough time to properly digest the essence of what they're saying and the evidence on which such a decision can be made. So, Your Honor, I'm happy to give an undertaking. The other respondents are keen to give the undertaking as well, without the court needing to decide jurisdiction, about the non-publication of just the explicit videos, and the non-provision of those videos to anybody, except IBAC and the VPSC, at this stage, until at least 4 weeks, and after 4 weeks, to IOB, and to, that's Integrity Oversight Victoria, and to the Integrity Oversight Committee of the Victorian Parliament. After 4 weeks from now, if IBAC has not adequately investigated the matter, to complain about the IBAC's failure to investigate. But other than that, we have no interest in that particular content. We will, however, raise the allegations that such content was disseminated, because that's a factual matter, Your Honor. And by the way, Your Honor, Mr. Flitner is prepared to give evidence in this proceeding about all the matters that he has put in his affidavit, and about the accuracy of his assertions. And Mr. Glenn Thexton is also prepared to give evidence. They're both available this evening as well to briefly give evidence in relation to Mr. Thexton's communication with the board in 2024, when he had first put the board on notice. Now, Your Honor, if you have access to the exhibit of Mr. Flitner that was to the affidavit that was filed today, I can point.
I still don't. Mr. Kuksal, I still don't have access to those for some reason. There's some suggestion
Your Honor.
of incompatibility. I think someone is working on it outside the courtroom at the moment. Can I just find out from Ms. Foley whether those undertakings are of any satisfaction to her client whatsoever? Of incompatibility. I think someone is working on it outside the courtroom at the moment. Can I just find out from Ms. Foley whether those undertakings are of any satisfaction to her client whatsoever?
Your Honor, I'm afraid to say that they are not. For two reasons. One is they are focused on the videos only, and our application concerns the allegations as well. But even in relation to the videos, the way that it has been described is quite a limited undertaking. And really, in my submission, what has been said by Mr. Kuksal makes very clear that there is an ongoing desire and intention to publish and to use the allegations for various purposes, and spread those allegations, and disseminate them, even more widely than perhaps we had imagined on the basis of the material currently before the court.
Sorry, Your Honor, I resent that. I resent that allegation. It has been implied that I...
Okay, thanks, Mr. Kuksal. What I'm actually going to do is make some orders, and then I will make some additional orders tomorrow in chambers, timetabling the matter to an urgent hearing, because that is what is needed. But in the interim, I'm going to make the following orders. Orders 1 to 3 below are made upon the applicant's undertaking to submit to such order, if any, as the court may consider to be just for the payment of compensation to be assessed by the court, or as it may direct, to any person, whether or not that person is a party affected by the operation of orders 1 to 3, or any continuation with or without variation of those orders, and to pay the compensation referred to in A. above to the person affected by the operation of order 1 to 3. The court orders that 1, 2, pursuant to Section 23 of the Federal Court of Australia Act 1976 and Rule 132 of the Federal Court Rules 2011, until the hearing and determination of the interlocutory application or further order, the respondents, their officers, servants, employees and agents are restrained from uploading, disclosing, disseminating, or otherwise publishing or causing to be published the Flitner allegations as defined in the applicant's concise statement filed in this proceeding, or any part of, pursuant to Section 23 of the Act and Rule 1.32 of the Rules, until the hearing and determination of the interlocutory application or further order, the respondents or any of them, their officers, servants, employees and agents, shall remove any matter or material uploaded, disclosed, disseminated, or otherwise published, or made available for publication by the respondents, their officers, servants or agents, which contains, records or refers to the Flitner allegations or any part of them or their substance, and refrain from re-uploading. 3, 4, 5, 6, 7. Pursuant to Rule 2.323 of the Rules, the following documents in the proceeding are to be treated and marked confidential, and shall not be available for inspection by any person, not a party to this proceeding. A. The confidential answer to the applicant's concise statement filed in this proceeding. E. The confidential answer JH2 to the affidavit of Jared Robert Heath, affirmed the 21st of May. D. Any document filed with the court that exhibits, attaches or contains the documents referred to in orders 4A and 4B above, or refers to or records the substance of those documents, and any document filed with the court that contains, records or refers to the substance of the Flitner allegations. Pursuant to Sections 37A F1B and 37A G1A of the Act, until the hearing and determination of the interlocutory application or further order, publication of the Flitner allegations, or any part of them, and of any document referred to in Order 4 above, is prohibited. Pursuant to Sections 37A F1A and 37A G1A of the Act, until the hearing and determination of the interlocutory application or further order, the person referred to in paragraph 1 of the confidential answer to the applicant's concise statement filed in this proceeding shall be referred to in connection with this proceeding, and in any documents filed in this proceeding, only by the pseudonym Person 1. The person referred to in paragraph 6 of the confidential answer to the applicant's concise statement filed in this proceeding shall be referred to in connection with this proceeding, and in any documents filed in this proceeding, only by the pseudonym Person 2, and publication of any information tending to reveal the identities of Person 1 and Person 2 is prohibited. Pursuant to Rule 10.24 of the rules, the applicant is permitted to effect service on the respondents of the following documents in this proceeding: by email at the respondent's last known email addresses being s-h-i-v-s@wisdom, spelled W-I-Z-D-O-M, journal.com, Peter at w-i-z-a-o-o-m, the originating application, the originating application, the originating application, and service pursuant to Order 7 above is taken to have been effected by the emails from Jared Robert Heath of Cause Chambers, Westgarth, sent to each of the respondents at 11:23 a.m. Australian Eastern Standard Time and 12:18 p.m. Australian Eastern Standard Time and 12:19 p.m. Australian Eastern Standard Time on the 21st of May 2025. Pursuant to Rule 2.323 of the rules, until a hearing and determination of the interlocutory application or further order, the affidavit of Lulu. She affirmed the 13th of May 2025 and filed in Proceeding VID 222/2025, together with its exhibits, and Anne Shears, known as the She Affidavit, shall be treated and marked confidential, and shall not be available for inspection by any person not a party to this proceeding. 10. Pursuant to Sections 37 AF1, B, and 37 AG1, A of the Act, until the hearing and determination of the interlocutory application, or further order, any information contained within, or derived from the She Affidavit, the redacted parts of the redacted She Affidavit, or any information contained within or derived, is prohibited. 11. Costs will be the costs in the proceeding. I will talk.
Your Honor.
Be in touch with the registry and someone will be in touch with the parties tomorrow morning with urgent timetabling orders as quickly as possible for the hearing of the interlocutory injunction.
Your Honor, we want to appeal this order. The order effectively prevents us from appealing it too, if the order is taken at face value, because what Your Honor has said is that we can't file the material that we have filed in this proceeding in relation to the appeal of this decision. So I would like Your Honor to consider that, and make an amendment that permits us to file the material in support of an appeal to Your Honor's orders.
Thank you, Mr. Kuksal. As you would know,
Kuksal,
I can't give you legal advice. If you wish to appeal
what Your Honor has said,
the orders, you are more than welcome to do so. Could you please adjourn the court? I will publish reasons in the next couple of days.